the OConnor Law Firm, celebrating 25 years of the privilege and practice of law.
As we enter, hard to believe, our 25th year of practice, 25 years of practice of law. And in that 25 years, I've learned quite a few things. Some good, some great, and some lessons along the way. And one thing you may be surprised of, I love being a trial lawyer. There's nothing better than stepping in the ring to be able to defend someone, to represent a cause, whether you're a plaintiff or defendant, where it's the right thing to do. But of course, that right thing to do is always subject to everybody's opinion. And but one thing I love about my job is that I'm able to represent people that I care about and that I like, and that is a good thing. But one thing that may surprise you is one of my favorite things to do is mediate cases. You know why? It's real simple. I can help people solve their disputes and save them lawyer fees. I know, I'm a lawyer. I want people to resolve their conflicts. I mean, that is really what court is for. It's for people who cannot resolve their conflicts through other means. And, you know, in today's day and age, a lot can be said, but people can talk to each other. But you first have to be willing to listen to the other side. Interestingly enough, I looked up the definition for mediation, just a rough definition. And the definition of itself is kind of interesting to me. Intervention in a dispute in order to resolve it. It also means an arbitration. That's a completely different thing, so I think that part of the definition is bunk. But is an intervention in a process or relationship. An intercession. Intercession. To intercede. That means a mediator's job is to get between the two parties. Well, you know, as a mediator, what I try to do, it's not magic. I actually do something that is what I think is the most important skill as a lawyer, and that's listen. I like to listen. You know, I don't know what you're thinking right now, just like you don't know what I'm thinking right now. And in order to find out, I have to what? Listen. You know, each of us may have one side of an argument, and we may think the other side is coming from a different point of view, when it turns out we're not that far apart. But here's the other thing. With trial comes risk. Anyone who tells you that this is a sure thing, we're going to win this case, has never really tried a case. Because let me tell you, I have won a lot of cases I should have lost. And yeah, I've lost a few that I should have won. I'll never forget those. I learned a lot from them. And thankfully, there's been more times that I've won cases that I shouldn't than lost cases that I should have won. But the reality is this. It's a bit of a gamble. Anytime you have 12 people from the community, 12 people are going to view things differently. In fact, you could try the same case to the same 12 people. Facts change a little bit as evidence comes in, and that's just how the world works. The verdict might change day to day. We each come to the table as jurors with different ideals, different values, and a different point of view. It's like eyewitness testimony, terribly unreliable, because you could have a guy running through a supermarket in a Spider-Man costume who is 6'11", and 10 minutes afterwards, somebody's going to say it wasn't Spider-Man, it was Superman, he's about 5'5". Eyewitness testimony is perception. It's not science. It's not provable beyond it. It's that person's perception, that person's opinion, which is important, of course, when you're talking about the risk of trial. Now, mediation. What does mediation do? How does it work? Let me just explain how I do it. And I've been very fortunate to deal with some very good people. You have to have people who kind of want to settle the case. But what if they don't want to settle the case? They don't have to. Mediate, I can't make them. I can't hold them down, give them a noogie and make them resolve the case. No. But what I can do is make them think about the consequences of not settling. For example, in divorce cases, myself and other lawyers say there's a choice you got to make. You want to put your kids through college, or you want to put my kids through college? Because you could spend thousands and thousands of dollars fighting about different things in a divorce, and it's going to end up done one way or the other. Sometimes you can reasonably predict what the judge will do, and sometimes you can't. It's just like umpires. Some umpires, I used to love pitching in baseball. If an umpire called the outside corner, I'd hit that outside corner all day long. And judges, they have different strike zones too. They try to be equal and make sure the law is applied equally, but everybody's got a different opinion, different perception. So knowing the judge and then knowing their habits is one thing, but it's a risk when you go to trial. More importantly, it's a lot of money when you go to trial. For example, for me, to do a week-long trial takes probably at least 2 to 3 weeks solid, if not more, to prepare. There's no substitute for training if you're a boxer, and there's no substitute for preparation if you're a lawyer. If you don't know your case backwards and forwards, you are going to get knocked out. You have to know your case. That is how good lawyering happens, when you know your case and you're able to adapt to the facts. Because I often tell people, for example, in criminal cases, there's like 5 things that happen. There's what's in the reports, there's what witnesses remember, there's what actually comes or is admissible, comes into evidence, and then there's what the lawyers argue, and then 5th, the most important, is what the jurors remember. So you'll go back through this. What's in the reports, what the witnesses remember, what is actually admissible, like hearsay and different things aren't admissible for good reason. You go, why isn't hearsay? Oh, that's terrible. It's a silly rule. It's one of them lawyer things. No. Because hearsay is that you can't cross-examine something said out of court. If Bob says right now that I'm wearing a purple shirt with a green vest, and I can't cross-examine him and go, this is green? This is purple. This is not purple. This is white. And this is black. You see, if you can't cross-examine the person who's speaking it, well, then it's hearsay. So, my point is this. In trial, there's risk. You never know exactly how it's going to come out. But what you can know for sure is that if you go to trial, both parties are going to have to do what? Pay their lawyers more. And they're not going to have that finality. They're not going to have that resolution. And especially in a divorce or a modification, the parties should try to get together and go, what can we do to solve it? If you've got kids involved, you definitely do whatever it takes to try to bridge that gap. Say, what can we do to solve this disagreement for us that's in the best interest of the child? And it's not about winning. In a mediation, I always tell people, if you both walk out equally as ticked off, then I've done my job. Because that's the nature of compromise. But you don't have to get ticked off. You can just listen to them. So, for example, I like to start off the mediation with each party separately. Say, tell me what's going on. And then I might throw some things back. Well, have you considered this? Have you considered this? And you know what's interesting? Then I'll go in the other room and what's going on? I listen to them. Kind of ease into it slowly. You got to know where someone's coming from in order to know where they need to go. Some people will never settle. Some people don't want to settle. And then they can pay the price of the ticket to get to go to trial. But some people, if you say, you know what, have you thought about this? If it's the dad in the case, it's not all peaches and herb. I mean, you got to get, a lot of work goes involved in raising children. You can't underestimate that. Try being a single parent, raising your kids by yourself. You're the only person who does laundry, does the grocery shopping, is the person who puts Band-Aids on the knee, the person the teachers talk to. It is an immense amount of work. So just to say, well, I'd like more time. Yeah, of course, no, all parents want their kids all the time. But the truth is, you can't do that. You can't split a kid. I often say that the goal should be you take a picture of your kid before the divorce and you look at their smile. Each parent's goal should be to get that kid's smile as close to it was before the divorce. And sometimes that means swallowing your pride and doing what is right.
Thank you for your support for 25 years from the OConnor Law Firm.